It's my feel-good breakfast show.
Dumela we Expresso on SABC3 as we welcome into the studio criminal defense lawyer and chair of the Law Society of SA Criminal Law Committee, Mr. William Booth, to speak about possibly one of the biggest South African criminal court cases of our time, that of Henri van Breda, that's been all over headlines. And I was asking you earlier on, William, whether it's an open and shut case, as most people might think. And you said no case is open and shut. But let's quickly talk about the comments that the defence has made with regards to this phone call, which seems to be one of the most pivotal points of evidence.
Yes, absolutely. I think just to answer your first, or reply to your first comment, no case is just open and shut.
Yeah.
Depends how the witnesses fare in the trial, and obviously depends on the defence and what witnesses they call. And again, don't ever forget that it's all about the state having to prove its case, not the defence having to establish anything, really.
Yeah.
If there's doubt, well, an accused must be acquitted.
Yeah.
Phone call relating to certain reaction and during that phone call, or the way somebody speaks during a phone call. I don't think one must make the most damning inference from somebody and how that person reacts when he makes a phone call after a particular incident. You know, the allegation is that there was a giggle, that he was calm. Again, people react differently after a particular event. This was obviously horrific. So the way somebody responds, the way somebody talks, their condition, let's say, after event, one must be very careful to draw the ultimate inference, and that is, well, he must be guilty because he giggled. I think there's talk that somebody, he might have had some sort of a speech issue.
Okay.
I think during the trial, the judge even mentioned, well, he couldn't really hear the giggle. And again, was it really a giggle, or was it just a nervous reaction to what had taken place? He might have been in a panic situation. So one has to be very careful in regarding that evidence on its own as damning. And again, he might be able to justify why he reacted like that.
Okay. There's also another piece of evidence that's contradicting Henri's statement, and that is of hair found in Marley's hand, assumed to be that of her attacker. What did they have to say about that?
Well, I think photographs were also shown in court about the length of Van Breda's hair, and that it couldn't have been as a result of Marley grabbing the hair during a potential struggle, that the hair could have been placed on in another way. I mean, hair on a towel might then be transferred to her. There's all different ways as to how, you know, potential evidence, incriminating evidence, may be explained. So, you know, I think the defence in respect of the hair seems to have made a very good point.
Yeah.
That, you know, his hair was so short, therefore you couldn't have grabbed it out, as it were.
Yeah, and let's talk about the person who's currently on the stand, Dr. Marianne Tiemensma, who is the expert forensic pathologist and clinical forensic scientist that's working on the case. And the fact that she is being put on the stand to testify while not being the same person who put forth the first report about the case and the circumstances surrounding it. So does it matter, the person that's testifying versus the person who wrote the report? How does that contribute towards the case?
Well, I think it is a very important factor. Because the person who has done the examination and has drawn up the report is the person who should be testifying about that. Yes, you can be asked to comment on somebody else's opinion.
Yes.
But at the end of the day, opinion evidence must be of the highest order. And often in cases, there's been a lot of criticism about how certain experts have presented their evidence. In other words, it's not really objective. An expert must be objective. An expert is called to assist the court, not to put forward a particular view on behalf of either the state or the defence. So I think as far as accepting the evidence and somebody testifying about somebody else's deductions, I think the court has to be pretty cautious before accepting that evidence as being so important that deductions can be drawn from it as to the issue of the wounds. The state is saying these wounds were self-inflicted. In other words, that Henri was trying to make out as if he'd been attacked as well. And this is a made-up story about the intruder attacking the family. So the defence is obviously tackling that and saying these are not self-inflicted. These were wounds caused by by the attacker. So the court has to be very cautious in all of this determination, and the defence might present evidence to counter this evidence later on.
Yeah.
Okay. Well, I feel like we can have another hour discussing and unpacking the Van Breda case. Henri Booth, thank you so much. Oh, William Booth. I'm sorry, I'm mixing the names here, thinking of Henri van Breda. My apologies. Mr. William Booth, thank you so much for today and unpacking and giving us insight into what's currently going on at the Henri van Breda case.